If you think this moment is about numbers on a whip count, you're already missing the danger. The clock isn't ticking because lawmakers suddenly found courage. It's ticking because multiple systems that are designed never to collide are now moving at the same speed, in the same direction, with no room left to slow down. What's happening right now isn't the political theater of an impeachment threat. It's the mechanical sound of constitutional safeguards engaging all at once, and that noise only starts when something has already gone very wrong. At first glance, the claim looks dramatic. A compressed window, a swelling list of signatures, a capital city hardening its perimeter. But the provocation isn't whether a vote will happen. It's whether the institutions meant to absorb shock are about to be tested beyond their tolerance. This isn't about humiliation or even removal. It's about whether the system can still compel compliance from someone who no longer recognizes restraint as binding. The pressure didn't begin on Capitol Hill. It began when the judiciary, the branch most allergic to spectacle, reached a point where silence itself became a form of negligence. Courts are designed to be reactive, not declarative. Judges rule on motions, not on moments. They do not signal Congress unless something has crossed from legal dispute into constitutional emergency. That boundary is sacred precisely because it's rarely acknowledged out loud. When it is, it means the normal sequencing of accountability has failed. What matters here isn't the personality of the man at the center of this storm. It's the pattern of escalation that forced the system's hand. When attorneys are removed from a courtroom under oath-related sanctions, the legal issue isn't embarrassment. It's integrity of process. The justice system cannot function if sworn representations become optional. Once that line is crossed, the courtroom ceases to be a venue for truth-finding and becomes a stage for obstruction. Judges know this. They also know when delay becomes complicity. The transmission of evidentiary material to Congress is not a flourish. It is an alarm. Historically, impeachment evidence travels slowly, filtered through investigations, committees, and months of political digestion. When that timeline collapses, it's because the risk of waiting outweighs the risk of acting. That calculation is never made lightly. It signals that the alleged conduct is no longer confined to past acts, but is actively undermining the present capacity of government to function safely. This is where the countdown begins to matter, not because of the symbolism of 72 hours, but because compressed timelines eliminate the usual tools of evasion. There's no room for messaging discipline, no space to muddy the record, no time to let outrage fatigue set in. Every statement becomes additive. Every reaction compounds exposure. In moments like this, silence can be as incriminating as speech, and speech can rapidly become evidence. The swelling list of legislative signatories doesn't represent a sudden moral awakening. It represents risk management. Lawmakers are acutely sensitive to proximity. When evidence migrates from partisan allegation to judicial documentation, the blast radius changes. Association becomes liability. Defense becomes endorsement. And once that shift occurs, the incentives invert. The safest position is no longer loyalty, but distance. This is why defections accelerate rather than trickle. Members aren't persuaded by rhetoric, they're persuaded by probability. When the outcome begins to look inevitable, staying aboard becomes irrational. This isn't cowardice, it's a survival instinct embedded in political behavior. But it has consequences. As the majority coalesces, the minority hardens, and that polarization feeds instability outside the chamber. The Capitol's security posture reflects that reality. Lockdowns aren't reactions to votes. They're responses to signals. Intelligence agencies don't mobilize based on speculation. They mobilize based on assessed threat vectors. When rhetoric shifts from grievance to apocalyptic framing, when language invokes existential struggle rather than political dispute, agencies recalibrate. History has taught them the cost of underreaction. What's often misunderstood is that incitement doesn't require explicit instruction. It operates through implication, timing, and audience conditioning. When a leader with a demonstrated capacity to mobilize unrest frames accountability as illegitimate force, the downstream effects are predictable. The law treats that predictability seriously. Words uttered in that context aren't protected abstractions. They're situational triggers. As the clock runs, each institutional response feeds the next. Congressional action increases judicial scrutiny. Judicial documentation accelerates prosecutorial review. Prosecutorial movement influences executive branch contingency planning. None of these actors are coordinating in the conspiratorial sense. They're reacting independently to the same signal, that the normal deterrents have failed. This convergence is what makes the moment dangerous. Systems designed to check one another are now reinforcing one another. There's no single off-ramp. Even if one pathway stalls, the others continue. That's why focusing on the arithmetic of a single vote misses the point. The process has momentum now, and momentum in constitutional systems is rare and hard to reverse. The prospect of a third impeachment isn't constitutionally exotic. The framers anticipated repeated misconduct. What they did not anticipate was the erosion of informal norms that usually prevent escalation to this point. Impeachment was designed as a release valve, not a recurring mechanism. When it becomes repetitive, it's a symptom of deeper institutional decay. The Senate looms in the background, often invoked as a firewall. But trials are not just votes, they are exposures. They pull evidence into the open. They compel sworn testimony. They force senators to publicly align with facts rather than narratives. Even acquittal carries a cost when the record is damning. Authority erodes not only through removal but through sustained doubt. Parallel to this runs the criminal track, quieter but more relentless. Courts do not pause for political convenience. Grand juries do not consider polling. If conduct meets statutory thresholds, charges follow process. The interaction between impeachment and prosecution is complex, but one accelerates the other by stripping away procedural shields. Once evidence is aired publicly, plausible deniability evaporates. The mention of extraordinary remedies like incapacity provisions isn't idle chatter. Such mechanisms exist precisely for moments when traditional accountability may move too slowly relative to the risk posed. Their discussion signals seriousness, not inevitability. It reflects a system stress testing its options under pressure. International observers are watching closely, not out of schadenfreude, but calculation. Domestic instability alters global risk assessments. Allies reassess reliability. Adversaries probe for distraction. The credibility of democratic governance isn't an abstract virtue. It's a strategic asset. When that asset wavers, consequences ripple outward. Inside political parties, fractures harden into fault lines. Loyalty tests fail when the object of loyalty becomes a liability. Those who leave early are condemned, those who leave late are blamed. The calculus is brutal and deeply human. Careers are being triaged in real time. Throughout all of this, the central figure's reactions matter less for persuasion than for documentation. Emotional escalation doesn't intimidate institutions accustomed to threat. It feeds them. Each statement is logged, contextualized, preserved. The very impulse to dominate the narrative becomes self-defeating when the narrative is no longer the battlefield. This is why delay is no longer a viable strategy. Delay works when attention wanes and procedures sprawl. It fails when timelines compress and evidence stacks. Once a judicial referral collapses the calendar, time stops being an ally. It becomes an adversary. As the hours pass, the sense of inevitability grows, not because outcomes are predetermined, but because options narrow. Choices that once existed disappear. The system doesn't need consensus to move forward. It needs thresholds. Those thresholds are being crossed one by one. The most unsettling aspect of this moment is how procedural it feels. There is no single dramatic act, no singular villainous flourish. There is paperwork, scheduling, security planning. Democracy doesn't usually end in a coup. It erodes through process failure. Conversely, it survives through process insistence. What we're witnessing is an insistence that has been delayed too long. By the time the vote arrives, whatever its margin, the real shift will already have occurred. The illusion that power can indefinitely outrun consequence will have collapsed. That illusion has been one of the most corrosive forces in modern governance. Its end will be quieter than its reign, but far more consequential. When people look back on this window, they may focus on the tally or the spectacle outside the building. But the lasting lesson will be about timing, about what happens when accountability mechanisms finally synchronize, about how quickly the ground can move once it does. The countdown, then, isn't just to a vote. It's to a verdict on whether constitutional authority still compels obedience, or whether it has become optional. That question will be answered not by rhetoric, but by follow-through. Pay attention to the next procedural step, not the loudest statement. Watch which institutions move without being asked. That's where the real story is now, and that's where the consequences will continue to unfold.